1. Polity and Governance. 1.1 Nari Shakti Vandan, Constitution, 106th Amendment, Act. 2023. Why in the news? Recently, Parliament passed Constitution, 106th Amendment, Act, 2023, to provide for one-third reservation to women in the Lok Sabha, state assemblies and the Assembly of NCT of Delhi. Key provisions of the Act. Articles amended. Article 239AA, reservation of one-third seats for women in the Legislative Assembly of the National Capital Territory, NCT, of Delhi. Articles inserted. Article 330A, reservation of one-third seats for women in the House of People, Lok Sabha. It also includes reservation of one-third seats for women under total number of seats reserved for SCs/STs under Article 330. Article 332A, reservation of one-third seats for women in the Legislative Assembly of every state. It also includes reservation of one-third seats for women under total number of seats reserved for SCs/STs under Article 332. Article 334A, provisions of this Act shall come into effect after delimitation after the first census taken after the commencement of this Act. Sunset Clause, provisions relating to reservation of seats for women shall cease to have effect after the expiration of 15 years. The reservation for women, however, can be extended by the Parliament by law. Periodic rotation of seats reserved for women after each subsequent delimitation as Parliament may by law determine. Provisions of this Act shall not affect any representation in legislative assemblies and the Lok Sabha until their dissolution. Need for women's reservation in legislature. Underrepresentation of women in legislature, only about 14% of the members in Indian Parliament are women, the highest so far. Average representation of women in state assemblies in around 8% only, and some states like Mizoram have no women legislators. According to the Inter-Parliamentary Union, India has a fewer percentage of women in the lower house than its neighbors such as Nepal, Pakistan, Sri Lanka, and Bangladesh. Political underrepresentation of women is a major reason for India's poor performance in the World Economic Forum's Global Gender Gap Report, 127th out of 146 in 2023. Patriarchal nature of political parties. Affirmative action for women is imperative to better their condition since political parties are inherently patriarchal. It would also help overcome the entry barriers like money and muscle power for women leadership at the state and national level. Gender sensitization of public policy. Women representation in the decision-making process is essential to address problems like lower female labor force participation, increasing crime rates against women, etc. Evidence from the reservation at local level. According to assessments by Oxfam India, reservation for women at local level led to a significant increase in the reporting of crimes, improved access to basic amenities like drinking water, schools, etc. 5 www.visionias.in www.visionias.in Copyright Vision IAS. Nudging women-led development. It can enable greater participation of women as public representatives in policy making at the national and state level. Concerns with the Act. Against inequality. Idea of reservation runs counter to the principle of equality enshrined in the Constitution, as women may not be competing on merit. Impact on voters' choices. Reservation of seats for women in legislature restricts voters' choices and runs counter the idea of self-determination. Non-homogeneous group. Women are not a homogeneous community, such as a caste group. Therefore, the arguments made for caste-based reservations cannot be made for women. Less impact on political empowerment of women. There are larger issues of electoral reforms such as criminalization of politics, internal democracy in political parties, etc., that might act as an impediment to political empowerment of women. Disparity across states. The Act provides for reservation of one-third seats across all Lok Sabha seats as against provision of reserving one-third seat in each state/UT as mentioned in 2008 bill. Rotation of seats. The Act provides for rotation of seats after every delimitation exercise as against after every general election to the Parliament/state legislative assemblies. Reservation in Rajya Sabha and Legislative Councils. Act does not contain any provision for reservation for women in Rajya Sabha and Legislative Councils of the states. Geeta Mukherjee Committee, 1996, recommended providing reservation for women in Rajya Sabha and Legislative Councils as well. Way forward. Timely implementation. Time-bound conduct and publication of the census data and delimitation exercise should be done to ensure timely implementation of the Act. Capacity building. Involve civil society and other institutions for training and mentorship of women leaders at local level to ensure their effective mobilization at state and national level. 1.2 Simultaneous elections. Why in the news? The Union government has recently notified an 8-member committee under the leadership of the former President Sri Ram Nath Kovind to examine and make recommendations on simultaneous election. About simultaneous elections. It is an idea aimed to synchronize the Lok Sabha, state assemblies elections, municipalities, and panchayat such that voters in a particular constituency vote on the same day. Simultaneous elections do not mean that voting across the country for all elections needs to happen on a single day. For instance, this can be conducted in a phase-wise manner as per the existing practice, provided voters in a particular constituency vote for both state assembly and Lok Sabha the same day. Arguments for simultaneous elections. Impact on governance due to frequent imposition of the Model Code of Conduct, MCC. Imposition of MCC puts on hold the entire development programs and activities of the union and state governments in the poll-bound state. Massive expenditure in conduct of elections. Elections lead to huge expenditures by various stakeholders on account of conduct, control, and supervision of elections. 6 www.visionis.in www.visionis.in Copyright Vision IAS. For instance, as per CMS data, formal expenditure by the ECI in 2019 Lok Sabha general elections was about Indian rupee 10,000 crores. Prolonged deployment of security personnel. About 2 to 5 state assemblies go to polls every 6-month period, which leads to a lock-in of Central Armed Police Forces, CAFs, and state police forces for prolonged periods. Other issues. Frequent elections disrupt normal public life. For instance, political rallies disrupt road traffic and also lead to noise pollution. Frequent elections perpetuate caste, religion, and communal issues across the country. Elections are polarizing events which have accentuated casteism, communalism, corruption, and crony capitalism. Shift in focus of governance and policy making towards populism for immediate political gains as against long-term prudential policy making. Challenges in implementing simultaneous elections. Operational challenges, constitutional and statutory concerns in extending or curtailing the existing terms of some state assemblies to synchronize the cycle for the first time. Need of amendment to multiple constitutional provisions, Articles 83, 85, 172, 174 and 356, related to conduct of elections and by-elections and no confidence motion. Logistical and warehousing issues requiring twice as many EVMs and voter verifiable paper audit trail machines. Impact to voter behavior, apprehension that national issues may dominate over regional issues or vice versa impacting voter behavior. Lack of familiarity with the idea, last simultaneous election was held in 1960s. Hence, an entire generation is not familiar with the idea of simultaneous elections. Therefore, there is a need to explain how and why one has to vote twice or thrice at the polling booth. Others, loss of political accountability to the electorate as elected representatives and parties will have to face elections only once in 5 years. Impact on economy at the grassroots level as many jobs are created during elections. Recommendations on implementation of simultaneous elections. Law Commission, 170th Report, 1999. Hold elections to the Lok Sabha and state assemblies simultaneously but withhold the result of elections till after the expiry of the term of the assembly concerned, the interval no exceeding 6 months. Parliament Standing Committee on Personnel, Public Grievance and Law and Justice, 79th Report, 2-phase synchronized election holding of elections of some legislative assemblies at mid-term of Lok Sabha and remaining with the end of tenure of Lok Sabha. By-elections to all seats falling vacant in a particular year be conducted together on a predetermined date/timeframe. Needy AIOG, Discussion Paper, 2017. Conduct 2-phase simultaneous election based on the recommendation of the Parliamentary Standing Committee. In cases of premature dissolution of Lok Sabha or state assemblies, the term of the newly elected House should be for the rest of what would have been the original term. In the event of no confidence motion, simultaneously move a confidence motion for formation of an alternative government. Fix 2 windows of 1.5 months each for holding all by-elections due in a particular year. Law Commission, Draft Report, 2018. Framework for synchronization of elections. Option 1. Advancing or postponing election timings in certain states, such that elections to all state assemblies and Lok Sabha may be held together. Option 2. Conduct elections only twice in 5 years. Option 3. Conduct all elections falling in a calendar year together. Replace the no confidence motion with a constructive vote of no confidence, through appropriate amendments. It further suggested the option of limiting the number of no confidence motions during the term of the House/Assembly. 7 www.visionis.in www.visionis.in Copyright Vision IAS. Conclusion. As the government explores the idea of simultaneous elections further, a thorough and transparent deliberation should guide any decisions to ensure that the integrity of our democratic process remains intact. 1.3. Artificial Intelligence and Elections. Why in the news? 5 Swiss political parties have signed a code of conduct agreeing to limit the use of artificial intelligence, AI, in their campaigns for the federal elections. Role of AI in elections. Predictive modeling. The prediction models can be built using AI. It will help determine the probability of a voter backing a specific candidate. Factors such as demographics, voting patterns, and issues that matter can be considered to build a model that helps identify the voters who will vote for a particular candidate. Social media analysis. Using AI, parties can analyze the trends and sentiment to build a social media outreach program, as per the voters' preferences. Personalization. AI can aid in tailoring communications for specific voters based on their interests, preferences, and traits. This can assist candidates in connecting with the audience more deeply. Real-time data analysis. Campaigns may adapt their messaging and outreach methods in reaction to shifting conditions by using AI to evaluate real-time data on social media trends, sentiment, and influencers. Increased efficiency. AI can track and measure the performance of various campaign activities such as advertising, canvassing, and events. This enables campaigns to identify what works and doesn't and make data-driven decisions to optimize their activities. Enhanced participation. AI also generates chances for participative democracy, like enhanced voter education and mobilization. Concerns associated with AI in elections. Manipulation. AI can be used to create deepfake videos, misinformation, and social media manipulation, influencing voters and distorting the truth. Public figures can be defamed or even blackmailed with deepfakes, influencing political life or withdrawing from elections or politics. Erode trust in elections. AI tools can be used to conduct an influence campaign that has the potential to undermine public trust in democratic institutions and elections. Lack of regulation. There is a lack of comprehensive regulation specifically addressing the use of AI in elections. Accuracy and data quality. The effectiveness and precision of AI systems deployed in political campaigns are hindered by the accuracy and reliability of the algorithms used, as well as the quality and quantity of available data. Cybersecurity vulnerabilities. Using AI to gather and analyze personal voter data raises privacy and data protection concerns due to lack of cybersecurity infrastructure, data storage devices, and increased cyber attacks. Way forward regulatory frameworks. Governments should establish clear regulatory frameworks for the use of AI in elections, including data protection and campaign advertising. Strengthen the Election Commission of India, ECI, to reduce the risk of AI misuse by political campaigns. ECI should strengthen disclosure requirements covering online communications. OECI must establish clear guidelines and ethical frameworks for the use of AI in elections, emphasizing accountability and responsibility. Innovation and detection. The government should ramp up efforts to promote innovation in the detection of deepfake, voting disinformation campaigns, and strengthen infrastructure to protect elections from cyber attacks fueled by language models and chatbots. Security agencies should create and share resources to help election offices address disinformation campaigns that exploit deepfake tools and language models to undermine election processes. Adaptive response. Continuously monitor and adapt to emerging threats and challenges related to AI in elections, responding swiftly to maintain the integrity of the electoral process. 8 www.visionias.anw 1.4 Personality rights. Why in the news? Recently, Delhi High Court granted protection to a famous Bollywood actor's personality rights from misuse by third parties. About personality rights. Personality rights refer to the right of a person to protect his/her personality under the right to privacy or property. It includes name, voice, signature, images, or any other feature easily identified as markers of personality. It is significant to protect privacy of individuals' right to derive economic benefits out of their personality traits, and consumers from misleading advertisements. Personality rights in India. Personality rights or their protection are not expressly mentioned in any statute in India but are traced to fall under the right to privacy and the right to property. Two components of personality rights: right to publicity, right to keep one's image and likeness from being commercially exploited without permission or contractual compensation. It is governed by statutes like the Trademarks Act, 1999 and the Copyright Act, 1957. Right to privacy, right to not have one's personality represented publicly without permission. It is broadly governed under the Article 21 of the Constitution and the Supreme Court judgment in Justice K.S. Puttaswamy, retired, case, 2018. Posthumous personality rights. Emblems and Names, Prevention of Improper Use, Act, 1950, protects unauthorized use of few dignitaries' names and symbols listed in its schedule. IPC, if negative reference or derogatory representation is made to any deceased person's reputation or their family, defamation suit can be filed under the Indian Penal Code. Trademark law, it ensures the benefit to refrain others from using others' name unjustifiably in addition to personal right to sue them for the misuse of others' name. Judicial interpretations. Titan Industries versus Rajkumar Jewelers case, 2012. Delhi High Court stated that personality rights include the right to not intrude upon their private space or solitude, publicly disclose sensitive facts, misrepresent their image publicly, or use their name to be unjustly enriched. Deepaja Kumar v. ALVJ case, 2019. Madras High Court held that personality rights cease to exist after the death of the personality and cannot be inherited by legal heirs. Sakshi Malik vs. Venkateshwara Creations Private Limited and Orr's case, 2021. Bombay High Court held that using another's image, and most especially a private image, without consent is illegal. Arun Jaitley vs. Network Solutions Private Limited and Orr's case, 2011. Delhi High Court stated the popularity or fame of individual will be no different on the internet than in reality. Challenges in enforcing personality rights in India. Conflict with the Constitution. Conflict between right to publicity, media's right to publish and inform public about matters of public interest, and citizens' right to know under Article 19. Absence of legislative framework. There is no existing comprehensive legislative framework to govern various facets of personality rights such as transferability of publicity rights. Dark patterns, deceptive internet techniques, and generative AI are difficult to regulate, which can infringe on individuals' right to privacy and publicity. Personality rights under international convention. There is no explicit 9 www www.visionias.in www.visionias.in Copyright Vision IAS. Conclusion. Personality and publicity to the right to be free from defamation and harassment. They are not only a legal construct, but also an embodiment of the fundamental principles of human dignity and individual autonomy. 1.5 Secretariat of the Parliament. Why in the news? As the Parliament completes 75 years, Parliament Secretariat has been the custodian of procedure, precedent, and legislative knowledge of the two houses. Constitutional provisions. Article 98. Each House of Parliament shall have a separate secretarial staff. Parliament may by law regulate the recruitment and the conditions of service of persons appointed to the secretarial staff of either House of Parliament. It also allows creation of posts common to both the Houses of Parliament. Article 187 makes similar provisions for Secretariat of State Legislatures. Council of States, Rajya Sabha, and the House of the People, Lok Sabha, came into existence in 1952. However, the Secretariat of the House of the People continued to be called the Parliament Secretariat, and a new secretariat called the Council of States Secretariat was set up for the Rajya Sabha. The names of the two secretariats were changed in 1954 to Rajya Sabha Secretariat and Lok Sabha Secretariat, respectively. Structure of the secretariats. Lok Sabha Secretariat. Speaker, Lok Sabha vested with ultimate guidance and control over the Secretariat. Administrative Head, Secretary General. Recruitment and conditions of service, governed by the Lok Sabha Secretariat, Recruitment and Conditions of Service, Rules, 1955 promulgated by the President in consultation with Speaker. The rules provide for strength and composition of the Secretariat. All appointments to the posts shall be made by the Speaker. Speaker may delegate to the Secretary General or any other officer of the Secretariat his power to make appointments. Rajya Sabha Secretariat. Chairman, Rajya Sabha vested with administrative control over the Secretariat. Administrative Head, Secretary General. Recruitment and Conditions of Service, governed by the Rajya Sabha Secretariat, Recruitment and Conditions of Service, Rules, 1957 promulgated by the President in consultation with Chairman, similar to Lok Sabha. 10 www.vision.ia. Other key information. Secretariat of both the houses has been divided into 10 services on functional basis like legislative, executive, and administrative services, verbatim reporting services, etc. Speaker and Chairman can create new posts in respective secretariat. However, for posts in Class 1 or Class 2, prior consultation with the Union Ministry of Finance is mandatory. Secretary Generals of both the houses hold rank equivalent to that of the Cabinet Secretary to the Government of India. However, in the table of precedence, Cabinet Secretary is placed at 11th position, whereas Secretary, Lok Sabha/Rajya Sabha are placed at 23rd position. Limitations of the Secretariats of the Parliament. Absence of legislative framework. No law has so far been passed under the Article 98 to regulate the recruitment and the conditions of service of the secretarial staff of either House of Parliament. Lack of autonomy. Parliament secretariats are often alleged of partisanship in favor of executive in terms of disallowing parliamentary questions, rejection of amendments and resolutions on flimsy grounds, etc. Lack of independent cadre. Most of the senior posts are held by those nominated from All India services, which adversely impacts the independence of the legislature. Conclusion. Through its dedicated efforts, Parliament Secretariat ensures that the wheels of the government keep turning smoothly, facilitating the lawmaking process, and upholding the principles of accountability, transparency, and representation. 1.6 News and Shorts. 1.6.1 108 migrants from Pakistan awarded citizenship in Gujarat. A Ministry of Home Affairs Order, 2021 empowered the collectors from certain districts in the states of Gujarat, Chhattisgarh, Rajasthan, Haryana, and Punjab for registration of citizen of India and grant certificate of naturalization under Section 5 and 6 of the Citizenship Act 1955 respectively. This is applicable in respect of any person belonging to the minority community in Afghanistan, Bangladesh, and Pakistan. Citizenship by naturalization can be acquired by a foreigner, not an illegal immigrant, who is ordinarily resident in India for 12 years throughout the period of 12 months immediately preceding the date of application, and for 11 years in the aggregate in the 14 years preceding the 12 months. Other qualifications as specified in the Third Schedule to the Citizenship Act, 1955. Constitutional provisions for citizenship, Part 2 of the Constitution, Articles 5, 6, 7, and 8, detail provisions regarding who will be the citizens of India at the commencement of the Constitution. Article 11 grants Parliament the authority to make any provision regarding the acquisition and termination of citizenship. 1.6.2 Disqualification of lawmakers. Karnataka High Court recently declared the election of a member of Lok Sabha from Hassan constituency as void. 11 www. The decision of disqualification is made on grounds of guilty of corrupt practices, including wrong disclosure of value of properties, evading taxes, etc. Representation of the People Act, RPA, 1951 enables the High Court to declare an election void on certain grounds. Once the election is declared void, the member has to vacate the office. The aggrieved person can appeal to the Supreme Court against the order of the High Court. Disqualification of a lawmaker is prescribed in 3 situations. RPA, 1951. Under Section 8, 4, a lawmaker is disqualified for the period of imprisonment and a further 6 years if convicted and sentenced to imprisonment for 2 years or more. 10th Schedule of the Constitution provides for the disqualification of the members on grounds of defection. Oh, Articles 102, 1, and 191, 1 for disqualification of a member of Parliament and a member of the Legislative Assembly respectively. Oh, the grounds here include holding an office of profit, being of unsound mind or insolvent, or not having valid citizenship. 1.6.3 Panel of Vice Chairpersons, VCS. Rajya Sabha Chairman constituted an all-women panel of VCs in Rajya Sabha. Under the rules of Rajya Sabha, the chairman nominates from among the members a panel of VCs. Any one of them can preside over the House in the absence of the chairman/deputy chairman. Oh, however, they cannot preside over the House when the seat of chairman/deputy chairman is vacant. In this case, President appoints a member of the House to perform the chairman's duties. He/she has the same powers as the chairman when presiding and holds office until a new panel of VCs is nominated. 1.6.4 Prison Reform. Parliamentary Committee on Home Affairs submitted report on prison conditions, infrastructure, and reforms. Key highlights. Oh, overcrowding. National average occupancy rate in prisons across India is 130.2%, with 77.1% of all the prisoners in the country being under trials. Oh, understaffed. Prisons are understaffed by approximately 30%. Oh, women prisoners. Of the total of 22,918 women inmates, 1,650 women inmates are with 1,867 children. Fewer number of women prisons and low representation of women in prison staff, only 13.77%, intensify their difficulties. Oh, prison budget. Only 0.6% of prison budget is spent on vocational/educational training of prisoners and 1% on their welfare activities. Recommendations. Oh, undertake a comprehensive study covering the population of the region, crime rate, etc. to develop a suitable plan to enhance the capacity of the prisons or another alternative. Oh, implement the Support to Poor Prisoners program announced in the Union Budget 2023. Oh, utilize technology like trackable bracelets to keep track of prisoners on bail. Oh, renovate colonial-era prisons to preserve their heritage and earn revenue by encouraging tourism. Oh, state governments may create a prison development fund for the welfare activities of the prisoners. Steps taken by the Center for Prison Reforms. Prisons and persons detained therein are enumerated in the state list of the 7th schedule of the Constitution. However, given the significance of prisons in the criminal justice system, Union Ministry of Home Affairs provides guidance and financial support to states. It has issued Model Prison Manual 2016 and Model Prisons and Correctional Services Act, 2023. 1.6.5 Public servants lose immunity in pre-2014 corruption cases. A Constitution bench of the Supreme Court, SC, declared that its 2014 judgment, which declared Section 6A of the Delhi Special Police Establishment, DSPE, Act 1946 as unconstitutional, will have a retrospective effect. 12 www.visionis.a and www.visionis. Section 6A of DSPE Act, inserted in 2003, required CBI to obtain prior sanction from the central government to investigate corruption cases against an officer of the rank of Joint Secretary and above. This provision was struck down as unconstitutional, violation of right to equality under Article 14, by SC in the Subramanian Swamy v. Union of India case, 2014. Key highlights of SC judgment. Once a law is declared unconstitutional on grounds of it infringing any of the fundamental rights guaranteed under Part 3 of the Constitution, it would be held to be an unenforceable right from date of enactment, void ab initio. Article 21 has no bearing in the context of declaration of Section 6A as unconstitutional, as Article 21 doesn't bar retrospective application of procedural changes in criminal trial. Article 21 lays down that no person shall be convicted of any offense except for violation of a law in force at the time of the commission of the alleged act. 13 www.visionis.a and www. 2. International relations.